about the Essentials Family Plan, which just was rolled out here beginning on October 1st. And it is largely the same as the existing family plan that we refer to, that's been around for quite some time. But there are some important changes to it, and we thought we would go through that. So what we'll cover tonight are the changes to the new Essentials Family Plan. We'll talk a little bit about some updates regarding the mobile app that members are using to initiate requests for services. Coming very soon, the members will be able to also initiate requests for service on a regular computer or a laptop via the web from a portal through the LegalShield website. So that'll be a web app, I guess is what they call that. We'll talk about some quarter three updates, what we've accomplished thus far this year. And then we're always happy to take your questions and we'll give you some answers.
Hey, Mike, the web version for your request for services was rolled out yesterday.
It was rolled out. Okay,
Yep.
Great. So we'll talk a little bit about that. All right. So the Essentials Plan, sort of a general overview. Some of the changes that have been made, we'll go through these in particular. But general comments: attorney has been replaced with the word lawyer throughout. That doesn't really mean anything different. They've just decided to change in terminology. I don't know why, but they decided to do it that way. Consumer credit services are now a specific benefit listed in the membership plan. And we can talk a little bit about what that means. The contract layout has been changed so that it's uniform everywhere. It really didn't necessarily look the same in all of the states for all members. So it's going to be uniform for all states. And that's part of a growing trend where LegalShield would really like to have the member experience be basically the same in every state. Now, there's going to be some reasons why that can't take place because the practice of law is a regulated business. And so those regulations are going to cause it to be a little different depending from state to state, but they're going to try to make this more of a McDonald's type experience where you get the same Big Mac in Alabama as you do in Pennsylvania, as you do in California. And then the general provisions of the contract, which previously were in the end, there are still some general provisions there, but they've moved the definitions and they've shifted a lot of different things that were buried inside the various benefits in the plan. They've shifted that to the beginning of the contract. And that is kind of typical for commercial type contracts that you would see out there, where it often starts with a definitional section that people can refer to whenever they're reading the contract. So I'm going to talk about these in no particular order. The consultation services, which is under the old plan, is under the new plan, really hasn't changed. What was removed from the letter writing benefit, they removed a clarification that an additional letter is at a 25% discount. They just took that out. So it doesn't mean that they get more letters. It doesn't really change the benefits that are available. They just took that provision out of there. I'm not really sure exactly why they did that. It may just be intended to indicate to a member that they may not get additional benefits for whatever that matter is under their plan. It really is going to depend on the provider firm deciding whether they want to continue on with it. And if so, they can decide with the member how to handle that. But that was just something that is removed for a clarification standpoint. On the document review benefit, they've added a section that wasn't there before that's called exclusions. Now, the plan did have exclusions to the document review benefit, but they've just, I think, set these out to make it a little bit clearer what types of services are excluded from the document review benefit. So they've moved the existing exclusion relating to documents in court proceedings into this exclusion sections. So court proceedings, the review of court documents has always been excluded from the document review benefit. They've just made it clearer in this new plan. And they've added a clarification that revisions or modifications of documents that members ask that we review for them are not covered by the document review benefit. And sometimes we do get folks asking us to mark up or make changes to documents, and that's just not covered by the benefit. We may agree to do that for them at a discounted rate, but it's not covered by the benefit. Estate planning services have some tweaks to it as well. They've also added here a section for estate planning exclusions. Again, trying to put all of the exclusions with the benefits to try to make it a little bit clearer for the member what you get and what you don't get. And I think it's a good change for the plan. And so these exclusions are not new. They've always been exclusions, either explicitly set out in the contract, or they're exclusions from the standpoint of what we've historically decided not to cover in the estate planning benefits portion of the contract, just as a matter of practice. And so the will benefit does not include planning for estate taxes, right? And that's when I say estate taxes, that's pretty much federal estate taxes, right? We don't really include that type of advanced estate planning. Complex distributions, and folks sometimes have a very complicated set of ideas about how they want to have their assets distributed. Maybe they've got several pieces of real estate and they want them all to go to different people, or they've got a very complicated scheme of dividing assets between their children and grandchildren or nieces and nephews. There are some basics that we will do for them under the free will benefit, but there are things that can be more complex or complicated that we say are going to be an additional charge if they want them. And we always tell members up front, what this is what your benefit includes, and this is what it doesn't include if we are presented with these situations where they're going to be an additional charge. And then we let the members decide whether those things are important enough to them that they would like to pay a little bit extra to have that kind of stuff done. Now, the plan specifically says that special needs or supplemental needs trusts are not part of the will benefit. Now, I can say from a practical standpoint in Pennsylvania, we do include those as part of this benefit, but that may not be the case in all states. So the contract itself says that they are excluded from the free will benefit. And that would be a special needs trust that is within the context of the will, and that's a very frequent way that it's done, or trusts that are not part of the will are not covered by the plan at all, other than under the preferred member discount. But when I'm talking about special needs trusts here, I'm talking about ones that would be built into the term of the will. So the Essentials plan also has a few changes to the motor vehicle related benefits. Whenever I was looking at this, I didn't change the old plan. So it seemed to me that they had increased the property damage limit for some additional services to 5,000. And maybe Belinda or Naomi can correct me if I'm wrong, whether that's an increase or not. I always thought it was 2,000 or 2,500, but somewhere along the way, they did increase that number so that if you have a property damage claim to your car and it's no more, the property damage is no more than $5,000, then you get some free attorney time to assist you with making that claim or working that claim out, perhaps with your insurance company, or, like my daughter on the south side just had somebody sideswipe her parked car and take the side view mirror off. That would be something that if I were accessing the benefits under my LegalShield plan, I would call and ask the provider law firm, hey, can you help me with this? Contact the person who did this, send them a letter, try to work something out for them, and you get some free hours under that. So this is not necessarily a benefit that I think a lot of people take advantage of, or they're aware that they can take advantage of, but it's really one that can really, really come in handy and give a lot of extra oomph to dealing with somebody, especially somebody that's hit your car or damaged your car that doesn't have insurance, right?
Yeah, Mike, I'd say a lot of our motor vehicle attorneys, they give the member this benefit even when the member isn't aware that they have it, going back and forth with the insurance companies and trying to get it resolved. Sometimes it takes more than a couple of letters, that sort of thing. So they do that. And yeah, I think some of the plans said 2,500. It may have been some of the older ones, and then there were some 5,000. So I think this is just adding consistency again, like you had referenced with some of the other benefits, just making it more across the board.
Thank you. Yes. And it also includes a specific provision right with the traffic benefits that tell folks that, if they want to utilize their traffic benefit, that those traffic tickets must be received by the provider law firm at least 5 days prior to the hearing that is scheduled for that traffic citation. And that's really, from a practical standpoint, it gives us an opportunity to talk to the member, take a look at the ticket, and find an attorney who would be available to attend that hearing. All of that just takes time. And so 5 days is really kind of the bare minimum. Even I think that's cutting it kind of to the bone to be able to find somebody to attend a traffic hearing for a member, especially in an area that's remote. That can be a real challenge to find lawyers, because there's not that many lawyers in some of the remote parts of Pennsylvania and other states. And they don't always have a lot of availability. So those are a couple of changes that you'll see in the plan. Not new, those are always there, but they're just maybe a little bit more prominently placed, in the plan. So there were really no substantive changes to the trial defense benefits, but the exclusions that were previously part of the trial defense benefits have been moved to the general provisions. I'm not sure why they did that, because they've been moving exclusions next to the benefits, but here they move them away from the benefits. I don't understand why they did that, but I'm just telling you that they've been switched to the general provisions at the end of the contract. And it might be that some of those exclusions also apply to other exclusions under the contract. I'm not sure, but you're just going to find them in a different location. So, you kind of have to be mindful when you're talking to your customers which plan they have, if you're talking to them about where to find these things in their contract in order to be able to help them navigate it. So it makes it a little bit more complicated, but they're not changed. They're just in a different spot. The general exclusions are at the end of the contract. And this is, I think, a little bit of a tricky change that I wanted to make sure that I bring to your attention. And maybe this isn't necessarily all 100% new news, but I wanted to make sure that you understand it, and I wanted to reinforce it. So in the general exclusions, of the plan, which is, at least on my copy, found on page 9, I think, right? 9 or 10. Yeah, I think it's on page 9 of the contract. It says general provisions and exclusions, and there is a section that's called general exclusions. This means that in this section, the things that are in this section are not covered at all under your plan, meaning there are no benefits under the plan of any kind for these matters. And the first and most important to understand is business matters, right? There are no benefits whatsoever under the Essentials Family Plan for business related matters. So if somebody calls us about a rental property, that's a business matter for purposes of determining whether there are benefits that are available, and it's not covered, right? If they want to form a business entity, technically that's not covered because that's a business related matter. There are no benefits for it. Not even preferred member discount, not discount benefits either. There are no benefits. And that's what it specifically says, that they're excluded from the contract, not eligible for the 25% discount, and will not be interpreted as included services under the plan. So I wanted to make sure that you understood that. There are just no benefits, including no discount, right? Including no discount. Now, that doesn't mean that all provider firms are going to refuse to talk to somebody who calls in under an essentials plan that says, I'd like to talk about forming a new business. They probably will talk to them, right? Or if they have a rental property, they might talk to them about it. But they might also say, it's not really covered under your plan. You may want to call your associate and purchase a business plan that would be appropriate for that situation. And we might tell somebody to do that, or we might tell somebody we'll talk to them about this particular matter. And just remind them that if you want to talk about this type of a thing in the future, you really should consider buying a business plan of some kind. So that's an important general exclusion. Another important general exclusion that previously was only part of the trial defense benefits, but now has been moved to the general provisions, and that's important, is matters covered by an insurance policy. Okay, it literally says any matters which are covered by any insurance policy or any other legal service plan. That previously only applied to trial defense benefits. This now applies to any matter under the essentials plan. So if somebody calls in about an auto accident, maybe they've caused an auto accident and they have insurance on their car, technically that matter is not covered by their membership plan. We wouldn't have to consult with them on that. I'm not saying that we won't consult with them, but that's technically what that, what that means. They can really be interpreted broadly. There are lots of different places that you can take that. So I just point that out, that that is a much broader exclusion. Think about all of the things that you have going on in your life that you have insurance to cover, including billing disputes with physicians because you have health insurance, disputes with dentists because you've got dental insurance. You've got all different kinds of insurance that cover matters, and it depends on how you really approach that. I don't think that we're going to interpret it like that, in any way. I think that this would really apply to a situation where you've been sued, maybe because your tree fell on your neighbor's shed, and there's a homeowner's claim filed against you, and the homeowner's insurance company is handling that claim, and maybe even has assigned an attorney to you because you've been sued. That's probably the matter where we might say, you've got insurance to cover this particular matter. You really should talk to the insurance company or to the lawyer that's been assigned to you, or if you've caused an auto accident and your insurance kicks in to cover that matter, that might be a situation where we would tell you that. But we've not really typically enforced that type of an exclusion, but it's out there. So I'm just calling your attention to it.
Yeah, Mike, I'll say our attorneys will consult with the member.
Yeah.
But we won't intervene in any way in the litigation, or, in circumstances where there's no lawsuit filed yet and no attorney's been assigned. Sometimes we can do letters or a phone call or something. Once there's a lawsuit and an attorney's been assigned to the file, we will not intervene, but we'll still give the member a consult, let them know what their rights are, what the attorney or the insurance company's obligations are to them, that sort of thing, but we won't get involved in the litigation itself.
Right. And on that topic, I'm going to take a detour here just for a minute before I talk about the IRS audit benefit changes. But I just want to make sure that everybody understands that it's very, very probably not a really good idea for you or for us or for a member to sell somebody a membership plan who is in the midst of litigation or has some type of a claim that's actively going on, right? Especially there's a lawsuit, that they're involved in some type of a lawsuit, right? That might mean that they've been served with a debt collection lawsuit, or they've received a notice for mortgage foreclosure, or a sheriff's sale, on their house or a property that they own. These are all things that we get called on all the time. And sometimes that's the very first call that a new member makes, and especially a new member that's been sold a plan by an associate. I'm just going to suggest to you that member is expecting that we're going to either solve their problem or agree to solve their problem, almost always at no additional charge. No matter what you've told them, no matter what good job that you've done, to help them understand the limits of what might be available to them. Their expectation is going to be that we're going to solve the problem, or we're going to take on their case at little or no charge. It's time and time again, that's exactly what folks have an understanding about. They don't understand that all you're doing is connecting them to somebody that's just going to have a conversation with them and say, you need to hire a lawyer, because that's really what that consultation is going to end up as. You need to hire a lawyer, right? The document review benefit does not include the review of court documents. That's a specific document review exclusion. So if you're selling somebody a membership who has been served with a lawsuit, and you're suggesting to them that this membership is going to help them, you're really telling them that we're going to do something that the contract says that we don't do. That person is going to have their expectations are going to, we're not going to meet their expectations. In almost every instance, it's a bad idea for you to sell somebody a membership that's in that situation. I know that that's counterintuitive, right? That if somebody's in a legal situation, this is a perfect time to sell them the membership. You know, it depends on the legal situation, but I'm telling you that if it's a lawsuit or foreclosure, or they've gotten an eviction, you know, served with an eviction lawsuit or something like that. Okay. These folks often, I mean, the only place that goes is you need to retain a lawyer, right? You need to retain a lawyer, and we can connect you with somebody that you can hire. And oftentimes they don't have any money to retain somebody. And they're going to be disappointed if we can't do something for them for free about that litigation. They're just going to be unhappy. So that's just a word of caution. I've had this conversation with associates many times, and I always tell them the same thing. That's a sale that you want to avoid. It's not a good sale. You're going to get a charge back, or you're going to get a cancellation. You know, we're going to get an unhappy customer. That's a better sale to say, you know, I don't think that this is really going to work for you for this particular matter. You know, call me another time, or I'll follow up with you, or something like that later on down the road. So I'd be happy to answer any questions about that, but that's just a sale that you should avoid. Okay, so let's talk a little bit about the IRS benefits. The old plan kind of broke up the free time that would be available on audits to the first 30 days, and then after the 31st day, right? You got like an hour for the first 30 days and 2.5 hours after on day 31 and beyond for an IRS audit. Okay. This plan sort of did away with that and just said you get 3.5 hours of time for an audit. Kind of makes it simpler. I agree with that. There is a new exclusion here. And the exclusion is that audit notices, in order to be eligible for this benefit, must be sent to the law firm within 30 days of the member's receipt, or it's not covered, right? So probably, you know, we'll give like 3 to 5 days grace time from the date that's on that IRS notice, because it's always dated. The IRS audit notice always comes in the mail, although much slower now because the post office can't seem to deliver mail within 5 days or longer. We were having trouble with that. That's another detour that I should take. If members tell you that they haven't gotten something in the mail from us, it's most likely because the post office is significantly delayed in sending things. We're having a lot of problems with members getting things even a week or two, or in some instances 3 weeks after we have dropped them in the mail to them. It's taking a long time to get things to them. So just a word of warning, you know, out there, if you get a member that tells you that maybe, you know, we said that we mailed them their will or something like that, and they still don't have it. There's significant delays with the post office. It's a shame. But anyway, this is a new exclusion. So if you have anybody that you're talking to, you know, about an IRS audit, you know, make sure that you tell them, don't delay getting that stuff to us. Okay. Let's see here. Oh, Belinda, you're sort of responding to some of those things. Great.
Yeah, I figured it was on topic previously, so I
Yep.
just answered it. Yep.
Great. Okay, let's talk about the consumer credit services benefit that's in the plan. So this is a new, quote unquote, new benefit in the plan. It's not really been identified as a benefit, like consultation benefit, like mortgage or home services or family law. This is a new benefit. It's basically the same benefits that are covered by the consultation benefits. It really isn't significantly different. We kind of do this stuff already under the consultation and document review and letter writing benefit. I think LegalShield sort of broke this out for a marketing purpose so they can say that it has a specific benefit for consumer credit services. We get a lot of consumer finance and consumer credit requests for services. It's always in the top 3 of the request for services that we get on an annual basis. So lots of folks call in to use their benefit for what are called consumer finance. Now that's kind of a broad umbrella. It covers a lot of different things, but it's very popular. A couple of important exclusions. Again, under this plan, documents relating to court proceedings, not covered. So if somebody gets served with a lawsuit, a credit card lawsuit, that's not technically covered by the membership plan. If folks call us about it, we're probably going to take a look at that at least just to see what's going on, because we need to know where it's filed. We're going to need to take a look at it to determine whether it's covered under the trial defense benefits anyway. So we look at a lot of these. We just don't outright refuse to look at them. And I'm not familiar with how all of the provider firms do this, but I suspect that the vast majority of them would look at these one way or the other, at least for the purposes of deciding where they need to send you if there's a referral. The other exclusion is that we won't revise or negotiate on documents that you've asked us to take a look at. So it might be that a creditor sends you an offer letter to work out a default or enter into a payment plan or something like that. Maybe you're involved in a loan modification negotiation on a mortgage that's in default. And you've asked us to take a look at those documents. We'll certainly take a look at them. We'll talk to you about them to help you understand what they mean and answer any questions that you have. And we might even make some suggestions on things that should be changed in those documents. But the plan does not include us making revisions and then sending those documents back out to you or confirming in writing what the changes are that we would suggest that you make. That's the same basically as changing the document. And we don't negotiate these with the other side. That's not included in the consumer credit services benefits. So that want to make sure that you understand that. Okay, 25% discount. I want to talk about this. I can't talk about it enough. I want to make sure that everybody understands it. So 2 things. Number 1, it only applies while the membership is current. So if a matter gets, if somebody retains an attorney because they've been referred by us and they cancel their plan, well, the fee that they're going to pay is going to go up, right? That it's going to go up if your membership plan is canceled while that litigation matter is ongoing. So you have to keep your membership current while that matter is going on in order to be entitled to that 25% discount, right? So that's an important thing to understand. Secondly, the 25% discount applies only to the attorney's hourly rate. Now, lawyers handle legal matters in lots of different ways. Sometimes they charge by the hour. Sometimes they'll charge a flat fee for a legal matter, so that maybe lawyers would charge you $500 to prepare wills. That's a flat fee type of engagement, right? Where that's all you pay. They don't charge you by the hour. It doesn't matter how much time it takes for them to prepare those wills for you. And there are a lot of things that are handled on a flat fee basis. That's really the way a lot of what I would call retail law firms are moving, law firms that do work for consumers. Even law firms that do work for businesses and commercial enterprises are being asked to have billing arrangements that are different than the traditional hourly billing arrangement. And they might want to, businesses want to be quoted a flat fee as well. It's not unusual. Preparing a mortgage note and a mortgage for somebody who is loaning money to a person who's buying a house. I quoted them a flat fee for that. If we form a limited liability company for somebody, we charge them on a flat fee basis, not on an hourly basis. So there are a lot of cases that are taken on a flat fee. The flat fees are not discounted under the plan. There's no entitlement to a 25% discount on flat fee arrangements. The same holds true for matters taken on a contingent basis. So auto accident or personal injury cases are typically handled on a contingency, meaning the lawyer gets a portion, only gets paid if you're successful and they get a portion of your settlement, whatever the money's recovered. Social Security disability cases are handled in that way. Workers' compensation cases are handled in that way. You know, those are some of the most common examples of matters that are handled on a contingent fee basis. There's no discount on those under the plan. The plan only entitles you to a discount for hourly matters. So it's important whenever you're talking to somebody who has a matter that is likely to necessitate retaining a lawyer, you want to make sure that you don't tell them that they're entitled to a 25% discount off of what the lawyer charges, because that would not be necessarily true. It's only on an hourly basis. So you always want to say it's 25% discount off of the lawyer's hourly rate, hourly rate. You don't know how the lawyer is going to charge for whatever they're doing. So you're probably better off just saying 25% discount off of their hourly rate. So let's see. Any questions about the mobile app? I'm sorry, about the changes to the Essentials plan before I move on to a few mobile app issues. Be happy to answer any questions about that. You can just unmute and belt it out. No? Okay, well, if you think of one after the fact, go ahead and put it in the chat or let me know and I'd be more than happy to answer it. Okay, so the mobile app is live, it's out there. People are definitely using it. And it's a work in progress, I'll just say. The technology is constantly changing on the mobile app. How we're learning how to service requests for service that are sent to us via the mobile app. And I think members are learning how to use the mobile app. So we talked about this. This was the focus of our last associate workout. I'm going to just go over this stuff very briefly for those who might not have been part of that or seen it, and maybe just talk about a couple of different issues. So in order for members really to get the optimum experience out of the mobile app, it's really important for them to understand how to use it. A lot of these requests for services that are submitted to us via the mobile app are not filled out completely, and that can cause some problems for us getting back to the member as quickly as possible. About 50% of our intakes or requests that are sent via the app have insufficient information. And my guess is that the same is going to hold true for the web-based app as well, if they send us a request for service on their computer. So a lot of this stuff I think is going to apply to that. The biggest problem that we have is members telling us who the opposing party is. So if they have a legal dispute, it's typically with somebody else, right? It takes two to tango, unless it's just a very general question. We need to know who that other person is that's on the other side of that. That's called a conflict check, right? Our rules of professional conduct require us to not give advice to somebody whenever we represent the other party, right? Or we've provided advice to the other person at some time in the past, right? And we've had lots of clients over the years. So it's important for us to make sure that whoever that other person is that you have a dispute with, that we've not done work for before, or they're not a LegalShield member. You know, all the LegalShield members are entitled to all of their benefits, but we just need to do that conflict check. And so we need to know who that person is. We need an actual name. You know, if you have their phone number, their address, as much information as you can give us, it's important for us to understand that. If we don't have that information, it's going to slow down the ability to get back to the member and connect the member with a lawyer, because my staff is going to have to reach out to your member and get that information so that we can do that conflict check before I can then connect your customer with one of my lawyers. So when you're talking to members about using the mobile app or the computer app, right, make sure that you help them understand that it's very important for them to complete that stuff. You know, you can't put in the opposing party, my neighbor or my friend or my employer. I think that the app is going to be changed a little bit to prompt folks to make sure that they know that they need to provide us this information. This is part of the process of working through this to see what's working and what isn't working. And so some of that is happening, right? But that's an issue that we've been having. You know, we got to have, the name has to be sufficient so we can identify the person. Okay, so the mobile app, since the
If I
last
can
time.
add one more thing.
Yeah,
too.
fire away.
You know, making sure that we have some sort of description of what the legal issue is as well is very important. Basically saying, just call me. And we actually have app submissions that say that, or just, you know, I need someone to call me. Generally, what's going to happen is our staff's going to reach out because we want to make sure that they're hooked up with the correct attorney for their legal issue. There are a variety of areas of laws, and I have a dozen attorneys that I supervise, all who concentrate in different areas of law. And so, you know, I need to know if it's a family law matter, or if it's a consumer matter, or if it's a criminal matter, so I can get that member to the correct optimum attorney to assist their issues. So, you know, when they leave that section blank, 9 times out of 10, they're going to get a call from our staff if we can't figure out what their legal issue is, so we can get that information and then pass it along to the attorney.
Yeah, thank you. That's a good call out, Belinda. We don't want to connect a member with, have a lawyer call them and they find out only then, oh, you're talking about copyright law and I'm a divorce lawyer. I have no idea about copyright law. I'm going to have one of my colleagues call you back. That's not the experience that the members are going to want to have, right? So asking them these questions is really them helping us help them by connecting them with a lawyer that knows and can give them the most advice right off the bat. Since the last time we talked, you know, the functions in the mobile app that face the customer have changed. And now they can see their request for services. And, you know, whenever we're working through these in our computer system, we're putting notes in and we have a process, right, that tells us to change the status of the intakes, right? So there are things that we do with it in our process that we call it different things, right? You know, it's just like if you're building a house, you would have the demolition phase, you would have the pre-construction phase, you would have the framing phase, right? They all have different names. And so the life cycle of a request for service also has different phases, and we call them different things to indicate sort of where it is in the process, right? And one of the names, one of the terms that we use is closed. And whenever we designate an intake closed, from our standpoint, what that means is that we've done what the member has asked us to do or what we've committed to do for the member. It might be that you've called us, we've consulted with you, and that's all that needs to be done. And there really isn't anything else for us to do. And so we close it for our purposes. Or you've called us, you've asked us to review a document. We said, okay, well, send it to us, and you send it. We look at it, we consult with you about it. And then there's nothing more to do, right? We've answered your questions about the document. And then we close that intake. Some members are seeing these status changes on their side of the partner app, and they're not understanding what they mean. And in particular, they don't understand closed. And Belinda can probably say specifically where this is coming about, but it might happen whenever we have agreed to prepare a letter for a member and we send the letter to the person, the addressee of the letter, right? From our standpoint, right, we've done what the member has asked us to do. And in our historical process, once we have sent that letter out, we close that intake. But from the member's perspective, well, it's not really closed because they're expecting a response from the addressee of that letter. And so they misunderstand that status change. And we might get calls from the member, sometimes upset saying, well, why is this closed, right? That's kind of what we've been seeing happening, Belinda. Is that right?
Yeah, I think
Yeah,
it's important to understand if you get one of your members contacting you saying, I just got a message on my app saying my file's closed, and Attorney Lasan, did a letter for me and told me, if she doesn't hear from, if I don't hear from her in the next 10 days, or there's not a response, to give her a call back, my issue's not closed, and they start, getting very upset with our staff, and then Noemi and our concierge Deb Serrani, or we have to like calm the member down. It's not closed forever. It's only closed for the purposes of, we've done what we need to do for the time being. And obviously, if there's a response or if the member calls back, we will reopen that file. It's one of those status changes that we really don't have any other place where we can put these with the way that the system is set up. The only time that a matter is past us, basically beyond our ability, is when we refer it out to another attorney, in which case that member is going to be retaining counsel at that point to handle their legal issue, or we have actually exhausted the intake because there really is nothing more we can do. And in which case the attorney will advise the member of that and also send them a letter to that effect. So when they see that something's closed on the app for whatever message they're getting, it's important, if they come to you upset, explain to them it's not really closed. It's just one of those statuses that we're going to be waiting to hear back from the other party. So, and we've asked LegalShield to kind of clarify that, and because we do understand the impression that they would get, and we certainly don't want the members to be upset.
Yeah, so maybe the terminology will change. This is part of this learning process that we're going through. Our jargon that we understand, members don't have any idea what it means. And, the best of intentions in planning all of this out, sometimes you can't get everything. So we're explaining that to you so that you can explain that to your customers. And it might be that this terminology changes, and maybe they'll change it to action taken or something like that. The next step, whenever somebody, in Belinda's example, when somebody says, I haven't heard from that addressee of that letter, it's been 10 days, and they call Belinda in, we reopen the intake or reactivate the request for service. That's what the status is from our standpoint. So this is a work in progress, and we just ask you to be patient with it. We're all sort of learning how to best work this out. Okay.
And Mike, if I may, real quick, our office,
I suppose.
our office, we send out emails to the members during every status to keep them informed of what's going on with our intake. And we have changed the wording of our email. Our emails do not say your intake is closed, because we recognize that was sending people into a frenzy. So we have taken that off of our emails.
Right. So, at the risk of over communicating with our members, right? Because they're getting stuff in the app, but they're also going to be getting messages to us, either emails or texts. We're trying to be a little bit more descriptive so that they understand what's going on. Couple of things that can prevent an ideal mobile app or web app experience: members not paying attention to what the app tells them about the process. And the app does tell them things about what the process is. And if you've used it, as an associate, that it's telling you a little bit about the process, right? Folks don't always pay attention to that, but it is trying to tell them those things. And that's why, to help them understand what's going on. Whenever you open a new request for service in the app, and I'm not sure this has been changed yet, but if it hasn't, it will be very soon. It gives you two callback choices. One would be ASAP, and then the other would be to schedule a callback time. They're getting rid of the ASAP callback choice. Thank goodness, because everybody defines ASAP in a different way. For some folks, ASAP means 10 minutes. Some people might mean something different. Even though when you select ASAP, the app tells you you're going to get a call back in 4 hours, not everybody pays attention to that or catches that or understands it, right? So they're going to take that out of there, and it's going to be it's just going to say within 4 hours. That's what I believe that's what it's going to say, because we've been running into a lot of misunderstandings about what ASAP really means.
Yeah, I think the ultimate goal, Mike, is from what I understand, is that they're actually going to give everybody callback time choices.
Uh-huh.
Instead of just within 4 business hours, that sort of thing, you'll be able to say, within, between 10 and 2, on this date, whether it's the next day or, that sort of thing. So ideally, that's where they're going to head. I think they're trying to gauge the call volumes, at different times of day, because they're also going to try and make sure that, we don't have everybody asking for the same time period on a given day. So.
Right. Again, it's a work in progress. We're trying to figure it out. It may not please everybody to have to pick a callback time because they don't know when they're going to be available tomorrow, those kinds of things. So we're doing our best. And I will tell you, it's very frustrating when somebody says, call me between 10 and 2, and we call them between 10 and 2, and they don't answer the phone. That can be frustrating as well, but we do our best. We let them know that we tried to call them, even if their voicemail isn't set up, which is not that unusual. Sometimes folks just don't realize that we did in fact try to call them because maybe their phone's on silent or vibrate, or they were in some bad zone or whatever. You know how it is. If you've tried to call other people in life on a cell phone and you can't get a hold of them, all the problems that you can have in getting a hold of folks. And we have them, except we have them 300 times a day. So just a little bit of a share there. Okay, incorrect uses of the app. To check on the status of an existing matter. Don't request a new legal matter. Don't open a new legal matter just to check on the status of an existing legal matter, right? Better to call us, text us. You have gotten some kind of communication from us. You can communicate back using that rather than the app. That's going to really be the best way to do it. So if you're a Pennsylvania member, you've gotten a text from us, you've gotten an email from us, and they both tell you that you can use email and text to get a hold of us. So that's really the best way to do it. Okay. Don't submit multiple app requests at the same time for the same matter. We end up having to just consolidate those into one anyway. So sending 3 doesn't mean that it's extra urgent. We're going to call you right back, kind of a thing. Sending documents, photos regarding an existing legal matter requesting a new matter to just send us documents on an existing matter. We get that too. Just send us the documents, the texts and the emails that we send new members whenever they have a request for service, tell them exactly how to send us documents. So there should be no misunderstanding about that.
Yeah, the risk of that is this member is going to end up getting called by a completely different attorney from the attorney that they've been working with, may have had a few consults with, maybe even the attorney's done a letter for them. And our CSRs might not catch that there's an existing matter on this already. So they'll be called by attorney B, and then, it basically only to find out that attorney A is the one who's actually assisting, and it causes a disconnect, and either the member has to reinvent the wheel with the new attorney, or we have to try and contact attorney A, get the documents moved to that file, and get the member called back. It causes a service delay, which we certainly don't want to happen for the member.
Right. And definitely don't use either of the mobile app or the web app for urgent matters or matters within pending deadlines. Really, the best thing to do is to just call us. Then we can really expedite your situation. But I just don't suggest using it for urgent matters and deadlines. So, if you're panicked the night before a hearing at 10 o'clock at night, don't request service that says, please call me before my 9:30 hearing the next morning. It just isn't going to work, right? And you might not believe that people do that, but they really do. So, please don't do that. Best would be to call us at 8:30 that morning and say, can you put me through to a lawyer? And we'll do our best to do it. I can't guarantee it because those types of deadlines are tough, but we will do our best. We always have a lawyer that is scheduled to be on call for urgent matters whenever that kind of stuff happens. But, if we get 5 people at 10 o'clock the night before saying, call me before my 9:30 hearing, it's not going to work. We just won't have the folks to do that, despite our best of intentions. So let me see here. Before I talk a little bit about stats, and I'm just going to button this up here very, very, very soon, as I know we're at the hour, and I know that your time is valuable. I just want to let you know that we have some webinars coming up. We're going to talk about small business tax issues on November 4th at noon. That'll be facilitated by our friends at Donnelly Boland. We have an estate planning for your family webinar. This is a will webinar on November 9th. I think Ed Toomey at our office is going to be doing that webinar. Ed's a very experienced estate planning attorney. Father's Guide to Family Court. Deshaun Furness, the head of our family law division, is going to be doing that webinar on the 16th at 6 p.m. So if you have questions about family court, especially for dads, but it'll be beneficial for everybody. Definitely one that you'll want to catch. Deshaun is really just, she's great. And our next Legal Shield Associate workout, we're going to talk about the traffic benefits again, because that was pretty popular. And so that's on November 17th at 5:30 Eastern Standard Time. As always, if you've missed an event, they're always posted for replay on our YouTube channel or Fiffik Law Group. And so if you just search Fiffik Law Group on YouTube, you will find us, and all of our webinars are on there. We typically post them a few days after we've done the live event. So that's it for that. Naomi, do you have the statistics very briefly?
Yes.
I'm just trying to see where they are. Stats for the meeting. Let me see. I'll open this up. It could be scary. Let me take a look and see what we got here. Maybe you could open them up because it's not opening for me.
Mike, while I do that, looks like we have a question from Mark. He has his
great.
hand raised.
Why don't you work on that and I'll do it. Mark, you can just go ahead and unmute if you want. Are you able to unmute? Yeah, there you go.
So my question is, I had stroke and I had hard time getting on. With the new mobile app, who can I call to help set up for me?
The mobile app. I think well, if you want, I think that's going to, you probably need, I'm just thinking out loud. If I were going to do that, you probably need somebody that can have your phone in their hand to do it for you. Is there a Legal Shield associate in your area that you're connected with that might be able to assist you with that? You can also use the one online. There is a web-based app too that you could use. It's going to be basically the same as the mobile app. If you go to LegalShield.com, you should be able to access your portal. And if you can use your computer at home, you will be able to do the same thing on your computer as you can for the app. But I'm thinking that you'd have to have somebody with you to set that mobile app up for you.
I also think member services may have some people who might be there trained up to assist with, how to submit the requests and that sort of thing, or at least give him direction.
Yeah. So you may want to call member services in that regard. You can always call us, of course.
Okay.
Okay.
You.
Sure.
You're welcome.
So let's see. We have some stats here. Total calls into the call center this year. Oh, here's somebody who's offering to do that for you, Mark. Katina is offering to do that. So very nice of you. Thank you so much for doing that.
I know Katina.
All right. Wonderful. It's a great community to be part of. So calls into the call center through September, 46,000. I think we had 57,000 last year. So it looks like we're probably going to exceed the calls into our call center. We have some of our calls that come in handled by our customer service representatives. And the idea there is to get folks the help that they need at the time that they need it. And if they can get some help as soon as they call in, and maybe it's a very simple thing that they need, not legal advice, but then maybe they need some help getting us a document or making sure that we've gotten their documents or something like that. Our team is trained up to be able to assist them in that regard. So we have them handle that. New intakes or requests for services, January to September, 17,000, and then reopen, meaning folks need to call us again about something. So we're at 31,000 or so. And I think we're on pace for 42,000. And that's going to be about a 5 to 10% increase year over year from last year. We set a lot of phone appointments, 2,700. We've done over 2,000 letters thus far this year for members. We've received 24,000 plus documents, 24,000 documents from members. That's not the pages, that's 24,000 documents.
Yeah, that's
So
not
God
pages.
only knows how many pages that is, probably closer to 250,000 pages of documents that we have
You don't want to know.
received, right? And I can guarantee you that our staff has looked at each and every page to make sure that we can read them all, right? And
Mhm.
all of that. So that's a ton. That's a ton of documents. It blows my mind how many we get. I'll just tell you real briefly, the Pennsylvania Bar Association receives 10,000 calls a year, 10,000 requests for services from Pennsylvania all across the state, looking for legal advice. You know, we've already fielded 31,000. So we're about 4 times the size of the Pennsylvania Bar Association, which is the main association for the entire state. That's the kind of volume that we're handling. Last year, I know this because I just looked at it, we handled 10,500 texts.
Mhm.
That we sent 10,500 texts to members in all of 2020. Thus far in 2021, we've sent almost 35,000 texts to members. And then members text us back, which is, we always love to hear from them. And our members seem to be very happy that they can get texts from us and send us texts. So we've gotten 6,600 responses from them, which is great. We've prepared almost 1,700 wills and powers of attorney for folks. I'm telling you, pound for pound, I don't think there's any firm that does more estate planning documents in Pennsylvania than we do. And I'll bet that that's true for every LegalShield provider firm in every state. They're probably the biggest producer of estate planning documents, really helping families plan and plan for the orderly transfer of your hard-earned money, your hard-earned savings to your kids, to your grandkids, to your siblings, whoever it is. We're helping folks do that in an orderly fashion. And I'm telling you, there are folks out there that don't do that. And I'm sorry that they don't. Half of Americans don't have wills, and it almost always causes a lot of extra expense and consternation. So a credit to you all as associates who are helping folks get all of that done. You're really doing a tremendous service for members of your community.
And Mike, if I may, real
yeah.
quick, with regards to wills, this year we just started tracking from March of this year to September, will queues that we mail in the US mail, like US postal mail, we've sent out. Belinda, what did I say it was? Hold on, I have it here because we were looking. We sent out about 400 will queues in the mail this year. And then that does not include the ones that we emailed to members, which brings us to around 700 new will queues, DGPOA nomination forms that we sent to our members.
Right. Harvey asked if the will count includes husband and wife. I think we count those separately. Is what
Yes,
my
they are
understanding is.
count.
Yeah, they're counted separately. So we've done at least one horse and buggy in notary session, because Noemi has done that for Harvey, for the Amish community that he has plugged into. So she has actually attended a drive up notary session where it was horse and buggy, if I'm saying that right. If I'm not, I apologize.
We have another
that was
one.
kind of fun.
We're going to be doing it again, Mike, in November. Harvey and I already
Wonderful.
talked about it before you came on.
Awesome. Right after harvest time, they'll want to be getting their wills done then. They'll have the work is done. So 7% of our requests for services turn into a referral. So that means 93% of the folks who call us, we're taking care of whatever their need is, with a telephone call, a document review, a letter written, something like that, right? Where they're not having to pay anything extra. It's a tremendous amount of benefits that we're delivering out there for folks. And I have a way of calculating that, and I didn't have a chance to do it before today, but we'll be sending out an associate newsletter, I think, here very soon, to just give you an update on what's going on. And I'll include all of the stats in there. And then early next year, like we did last year, we're going to produce an annual report and let you know what we have all done as a team, you and us, what we've done as a team to deliver access to civil justice in Pennsylvania in 2021. So you're doing a tremendous job. So let me answer a couple of questions here before we tie this up. Let's see here. We've got, you don't charge retainer fees for legal matters, do you? Yes, we do. Most law firms will charge a retainer for a legal matter. Typically, if it is a matter that they take on an hourly basis, they're going to charge a retainer against what they're going to be charging on that. They're not going to charge the whole amount up front, but they're going to get some amount of money, especially if you're going to enter your appearance in a litigation matter. Every lawyer is going to ask for payment up front. And in certain flat fee matters, they're going to ask for the entire payment up front. So that's very typical for a bankruptcy. They're going to want to get paid up front in most bankruptcies. Criminal matters, they're going to want to get paid up front. And if you're representing somebody at a hearing that's sort of a one-day hearing in front of a magistrate or an arbitration panel, the lawyers are typically want to get paid up front on a flat fee basis. So that's how that works. Simple trusts are not included in the free will packet. Trusts, if there are trusts, there are testamentary trusts, and then there are living trusts, right? Testamentary trusts are trusts that only come to life after you pass away, and they're set forth in your will. And so one very simple example of that is in your will, you say, to my kids, except for any kid that's under age 21, pay that money to the trustee to be administered in accordance with the terms of the trust set forth in paragraph 3 of my will. That's a testamentary trust. It only comes into existence after you pass away and only under certain circumstances. We do those regularly as part of the will benefit. However, if you have a living trust, meaning a trust that we create that you sign now, that you put money into now during your life, okay, that some people call it a living trust, irrevocable trust, an irrevocable trust. There are lots of different trusts that you can create out there. Those are not covered by your will benefit, right? Those are going to be something that will be an additional charge, okay? All right, I know we're over time, so I want to respect your time. I appreciate you all attending tonight. I'm sorry that I was a little bit tardy, ran into a lot of traffic this evening, but I hope that we will see you at some of our webinars coming up here in November, and especially at our next associate workout next month. So thank you very much. Happy selling. Have a great night, everybody.
Thanks, everyone.
Bye-bye.
Thank you. Very informative.